Tax attorney John Heyer here. We're going to discuss providing services to your IRA and that you shouldn't. There's an opinion out there that you only have a service provided to your IRA if the IRA pays for the service. Let's dig into that a little bit because I think it's mistaken, with all respect. Prohibited transactions destroy IRAs. One prohibited transaction, to quote the code, is furnishing services to an IRA. Now there's a bankruptcy court case that says, well, you don't have a service unless the IRA pays for it, because to have a prohibited transaction, we need to have a transaction. And the transaction only exists if there is both a service provided by a disqualified person, such as the owner of the IRA, and payment for it. I think that's mistaken. Let's get some context here. Why are we discussing tax issues in bankruptcy court? Why is a bankruptcy court judge talking about prohibited transactions? Because in bankruptcy, very intelligent creditors will go after a self-directed IRA and look for a prohibited transaction. Why? Because if there's a prohibited transaction in an IRA or similar account, HSA, Coverdale, etc., the assets are deemed distributed from the IRA. They're now deemed to be owned by you, and they're no longer protected in bankruptcy. So it's a way for creditors in bankruptcy to take assets that are safely in your IRA and move them into the unsafe world of personal ownership by saying, we have a prohibited transaction, the assets were deemed distributed. So it is relevant. The bankruptcy court ruled that there cannot be a service, because providing a service to your IRA is a prohibited transaction, destroys the IRA, leaves the assets open to creditors. There cannot be a service without payment for the service. Oh boy, so we can do all this work for our IRA and we're safe because as long as we don't pay for the service, we're all good. In bankruptcy, maybe, not in tax court. That has no precedential value in tax court, and the tax court, A, knows a lot more about taxes, oddly, than the bankruptcy court. B, the tax court tends to read things literally, which, by the way, is a good way for judges to approach the law. We don't want judges to make up the law. We simply want them to interpret it. The tax court is very literal. What does the code say? If you furnish a service to your IRA, you have a prohibited transaction. Does it say if you pay for it? No. It simply says the furnishing of a service. We don't know what that means. So far, it's never gone to tax court. I would not take a false sense of security in thinking that I can do whatever I want for my IRA tax-wise, not have a prohibited transaction because there's no service since I didn't pay for it. The bankruptcy court ruling has no precedent in tax court. It's not binding. It means nothing to the tax court. And frankly, I don't think that's how the tax court's going to read things. Don't get me wrong. If you ever find yourself in this situation, I hope you don't, will I argue that a service requires payment in tax court? Of course. Will I win? Who knows? So don't take a false sense of security from a bankruptcy court ruling that does not apply to the tax court. These are subtle things we discuss online and in webinars. How can you put far more money into self-directed IRAs and 401ks? Find out. Puerto Rico, April 20th and 21st. TaxReductionLawyer.com.